Good afternoon, Mr. Lee.
Good afternoon, Your Honor. May it please the court, my name is Tom Lee of the Nashville Bar. It is my pleasure and sole responsibility here today to introduce to the court Ms. Leslie Ahari, who will be arguing in principle for the appellants today. Ms. Ahari is admitted pro hoc vice before this court, and she is a member of the bars of the District of Columbia and the Commonwealth of Virginia.
Wonderful. We're pleased to have her with us.
Thank you.
Good afternoon.
Good afternoon, Your Honor.
And I think I saw you watching arguments this morning, so you are familiar with what we've been doing.
Actually, I was here yesterday watching.
Yesterday, okay, then there you go. All right. Glad to have you back.
Thank you so much. And I will say, despite my white hair and reading glasses, I also am a rookie here today. So
Good. All right. Well, we're glad to have you, and you might tie your shoelaces too. So
You're a rookie here, not elsewhere.
somewhere else. So good.
So I speak on behalf of the appellant insurers. This is an insurance coverage dispute. The insured is Envision Healthcare Corporation, which is the current name of the company following a 2016 merger between Envision Healthcare Holdings and AmSurg Corporation. The insurance policies in dispute are directors and officers' liability policies issued to the post-merger entity Envision. The Envision policies cover only claims made after the merger closing. They include an endorsement called the prior acts exclusion, which excludes coverage for claims that are based upon or arising from any wrongful act that is committed or allegedly committed in whole or in part before the merger on December 1, 2016. In other words, the Envision policies provide fresh, clean slate coverage going forward after the merger and do not pick up any exposure for pre-merger conduct. The Chancery Court ruled against the insurers based on the prior acts exclusion, and that, of course, is why we're here today. The pre-merger companies, the old Envision and AmSurg, each had their own policies that provide coverage for pre-merger conduct. Those policies provide $145 million worth of limits of liability combined. At the time of the merger, those policies were put into runoff, which means that the policy period was extended so that claims that were made within 6 years following the merger would be covered, but only for post-merger conduct. But in addition, the AmSurg runoff endorsement says that wrongful acts occurring after the closing that are related to wrongful acts before the closing are deemed to have occurred before the closing, so they will be within the runoff coverage. And this is in the record at volume 3, page 350. This is called the straddle clause because it addresses what happens when there is conduct on both sides of the merger. And I mention it because Envision's brief skips over it in discussing coverage under the runoff towers. And Mr. Lee has reminded me that I forgot to reserve 4 minutes for rebuttal.
All right.
Thank you.
Then if you'll do the math on that, please, and I should have reminded you myself.
Rookie mistake. Envision and the directors and officers are defendants in a securities action filed by a single class of shareholders who include the shareholders of the pre-merger companies as well as post-merger shareholders who received their shares in connection with the merger. Envision is in the healthcare business, and one of its subsidiaries, MCare, provides physician staffing for emergency rooms. The shareholders allege that Envision oversaw an out-of-network billing scheme which drove its revenue and growth. In its public statements over a 3.5-year period, Envision stated that its strong financial results were due to high quality, good patient services, and other good operational practices. But the shareholders allege that the real reason for the revenue growth was not the operating strengths, but rather its out-of-network billing practices. MCare allegedly would staff emergency rooms with doctors who were out-of-network and then bill health insurers and patients at much higher rates than would be permitted for in-network. Envision supposedly knew that its out-of-network billing was not sustainable and that it could not continue to generate revenue and growth this way. By 2014, Envision already was seeing a decline in out-of-network billing reimbursements. And the shareholders allege that Envision wanted to merge with another company so that it could mask the decline in revenue derived from acquisitions. With revenue derived from acquisitions. In March of 2016, Florida passed legislation prohibiting out-of-network billing. At that point, financial analysts began questioning Envision about the impact of the new law. And even though its stock price took a hit at the time, Envision allegedly still did not tell shareholders that its revenues were declining and unsustainable. In June of 2016, Envision and AmSurge agreed to merge. The merger closed on December 1, 2016. In the post-merger company's first annual report filed with the SEC in March of 2017, Envision said it would not be heard by the Florida law. And Envision allegedly still did not disclose that out-of-network revenues were falling. And then in July of 2017, the New York Times reported on a report by the National Bureau of Economic Research, which strongly criticized MCare's out-of-network billing practices. And then in October 17, Envision reported that its financial results were much lower than expected. And only then did Envision finally disclose that out-of-network revenues had been dropping dramatically and that its revenue forecast going forward would be down. In support of their case, the shareholders' complaint identifies statements made by the defendants during the class period, which is February 2014 through October 2017. The vast majority were made before the merger closing. The plaintiffs say that the original and amended joint proxy registration statements filed with the SEC before the December 2016 closing of the merger included misstatements and omissions about historical results and expectations for revenue and growth for the combined company. At the same time, it allegedly did not disclose that out-of-network revenues were unsustainable and had been in decline since 2014 because health insurers were refusing reimbursement. The shareholder complaint alleges 8 counts, which assert 8 different legal theories, all based on the same conduct, the alleged misrepresentations about out-of-network billing. Envision gave notice of the lawsuit under the 3 towers of insurance policies, the 2 runoff towers and the Envision go-forward tower. The insurers on the runoff policies accepted coverage for the securities litigation. And between the insurers on both towers, they have to date paid 100% of the defense costs in excess of the retentions under those policies. On the go-forward tower, the insurers denied coverage based on the prior acts exclusion because it excludes coverage for claims that are based upon and arising from wrongful acts committed before the merger. Envision did not challenge the denial for over 3 years. And then in 2021, there was a trial court decision from Delaware in a case called Northrop. And Northrop held that a prior acts exclusion in a go-forward policy issued to a post-merger entity did not apply because that entity did not exist before the prior acts date. And so
prior to the Delaware case, was it the position of everybody that the runoff policy would cover all of these claims, and then after the Delaware case, they made the argument that no, in fact, it's your all's policy that applies, or was that litigated at all before the Delaware case?
Well, it certainly wasn't litigated before the Delaware case. What happened is that the defense costs were allocated between the old Envision policy and the AmSurge policy, and Envision's coverage counsel was involved in that discussion. And it was agreed that those policies between them would provide coverage for 100%. And then, but at that point, Envision's coverage counsel had not told the insurers that he disagreed with the coverage.
So you all were working cooperatively until the Delaware case?
That's correct.
Okay.
So a critical fact, and the reason why Northrop does not apply here, is that Envision, the insured organization under the go-forward policies, did in fact exist before the prior act's date. Envision was formed in June of 2016, and it was then called New Amethyst. After the closing, New Amethyst was the surviving corporation, and it changed its name to Envision. There's no dispute that Envision and New Amethyst are the same company, and that the company under both names is an insured organization under the go-forward policies. And in fact, when the primary policy was initially issued, it identified the insured organization as New Amethyst. And then later, after the name change, that page was replaced with the new name. And it was New Amethyst that filed the original and amended joint proxy registration statements before the prior act's date. And it also is important to this case that 2 officers of New Amethyst signed the joint proxy registration statement in their capacity as officers of New Amethyst. So based on these facts and the complaint in the securities lawsuit, the prior act's exclusion applies. First, we have a claim, and it doesn't matter here whether the claim is considered to be the lawsuit as a whole or each count in the complaint, as Envision now argues that it is. Second, there's a wrongful act, the misstatements and omissions in the joint proxy registration statement. Third, the wrongful acts were committed or allegedly committed before the prior act's date, the merger closing. And then fourth, the claim is based upon and arises from these wrongful acts. The securities lawsuit as a whole and counts 1 and 2, which are the 2 counts for which Envision seeks coverage, are both based specifically on the joint proxy registration statement.
If I understand the insured's argument correctly, they are arguing that for the prior act's provision to apply, the act needed to be by an officer or director in the capacity of an officer and director, and that doesn't exist here. Did I correctly state that, or?
So it does exist here because the insured persons, the officers of New Amethyst, signed the joint proxy registration statement in their capacity as officers of New Amethyst. So that's an insured capacity. I think what Envision tries to argue is that the complaint doesn't specifically allege that the claim is for their liability in that insured capacity. And our response to this, and we addressed this in our reply brief, is that the language of the exclusion is that the claim needs to be based upon, arise from, or in consequence of the wrongful act. That is different than saying that the claim is for liability based on that wrongful act.
All right, thank you. We'll hear from you further on rebuttal.
Thank you.
Good afternoon.
My name is Steve Riley, and I too, like my colleague, Mr. Reed, have a very limited role of introducing to the court Mr. Michael Ginsberg, a member of the Pennsylvania Bar, admitted pro hoc vici. And I would also like to ask if we could put up, we have the policy language poster, we've provided that to the other side, and it might be a part of the argument if we could put that up on a...
Ms. Ahari, any opposition?
I don't, Your Honor, I don't object to...
All right, thank you. Okay. Good afternoon, sir.
Good afternoon. May it please the court. Michael Ginsberg on behalf of Envision. I guess it only has to be said I'm also a rookie in this court. I do appreciate the opportunity to be here today.
We're just having a rookie class today.
This is rookie day.
My hair is as gray as Ms. O'Hara's, but I have less of it. Let me be clear, Your Honors, about what this case is about. The insurers from whom Envision bought $140 million of directors and officers liability coverage are trying to escape their coverage obligations for a lawsuit against their insureds that seeks billions of dollars in damages. The insurer's position in this matter has been, since the beginning, relying on a misstatement and misreading of the Bettis case itself, the underlying complaint, and a similar misreading and mischaracterization of their own policies. I have this demonstrative here just because it's important to see this prior acts exclusion and what it really says. First of all, it requires that there be a claim based on a wrongful act. There is nowhere in the Bettis complaint that alleges a claim against the two individuals who were the officers of New Amethyst, Mr. Holden and Ms. Golmy, or against New Amethyst based on this joint proxy registration statement. Ms. Ahari said it again, but there is nowhere in the complaint where that allegation is made or a claim is brought for that reason. So there is no claim based upon or arising out of or in consequence of a prior wrongful act. It's not there. It's not there. In fact, when the insurers first raised this prior acts exclusion, they said, well, there were all these acts in 2014 and 2015 that were alleged, but those acts were alleged against people who were not in the insured capacity because they were not officers and directors of the insured organization. In other words, in order for the prior acts exclusion to apply, there has to be a wrongful act by an insured person, meaning someone in the position or capacity of the insured person that causes him or her to meet the definition of insured person. An insured person is someone who is an officer or director of Envision Healthcare Corporation. Envision Healthcare Corporation didn't exist until the middle of 2016. When it was called New Amethyst. There are only two officers of New Amethyst, Mr.
So
Holden and Ms. Golden.
what would cover pre-merger conduct? When you have entities merging, obviously you're wanting to make sure you have coverage both for pre-merger activities and post-merger activities. And so if we read this policy as you request and as the trial court found, is there any coverage for pre-merger activity that affected the stock of Envision, but that was done by officers who were part of a company that changed its name when it merged? You see what I'm saying?
Yeah, so
Where is the coverage?
So there are three towers of coverage. There was an AmSurge tower of coverage. There's an Envision Healthcare Holdings tower of coverage. Those two companies merged to become New Amethyst and then Envision Healthcare Corporation, the insured under this current policy tower that we're talking about. Part of the merger obligation of New Amethyst, Envision Healthcare Corporation, was to buy tail coverage, runoff coverage. So for acts before the merger of directors and officers of AmSurge or Envision Healthcare Holdings that resulted in claims after the merger, you look to those two towers. For acts after the merger that resulted in claims, you look to the Envision Healthcare Corporation tower. That's what this case is about. Acts alleged to have occurred after the merger, which resulted in claims during this policy period, during this policy. So you have three towers of coverage because all three towers apply to different wrongful acts and to different claims.
So you're not so as and let me just say, this is very complex and requires a lot of drilling down. And so if I'm at surface level, I apologize. I'll get there eventually. And now I think I've forgotten the question I was going to ask. But basically, if you're talking about what the allegation is there were two, and I think what's left after, now that we're here, is we have two distinct acts. One had to do with a filing that was done under the name of New Amethyst with the two officers and directors' names on it. And then we had something that was filed with the SEC afterwards. So we have a pre-merger and we have a post-merger. Two actions, that's the allegation, where they puffed up whatever.
Right, so the allegation is that that there were false statements in the joint proxy registration statement, which is what you're referring to.
Yes.
It was filed in 2016, before
Right.
the merger. The allegations in the Bettis complaint with respect to the joint proxy registration statement are made against the AmSurge directors and officers covered under the AmSurge tower, and against the Envision Healthcare Holdings officers and directors covered under the Envision Healthcare Holdings tower. There is no claim in the Bettis complaint against Mr. Holden or Ms. Golmy or New Amethyst. New Amethyst doesn't even appear in the complaint for the joint proxy registration statement. They are sued.
What about the post-merger statement, the filing?
Yeah, the post-merger statement is clearly not a prior act because it happens after December 1, 2016, which is the date of the prior act.
There's no dispute that where that's covered. It's just it gets muddled because we're saying it's all part and parcel
Well, there
of
is
one.
I'm sorry, Your Honor. Yes.
Go ahead.
No, there is a dispute about where that gets covered because the insurers want to overread this prior acts exclusion. They want to say, oh,
Right.
Mr. Sanger was an officer of Envision Healthcare Holdings. He made it a prior statement that gets repeated in this 2017 statement, and therefore there's a prior act. But Mr. Sanger's prior statement was made in a different capacity, so the prior acts exclusion cannot apply. And what Ms. Zahari doesn't tell you is when they sent the letter saying the prior acts exclusion bars coverage, they didn't say, oh, by the way, it doesn't really bar coverage because these people you were saying made bad statements, said them in different capacities. They were not insureds under this policy. In order for the prior acts exclusion to apply, the person making the statement, committing the prior act, alleged wrongful act, has to have done so in the capacity of an insured person under the policy you're looking at. And that didn't happen. That did not happen, and it's not alleged in the Bettis complaint, which is what we have to look at. If I'm wrong on the prior acts exclusion, whether it's in fact in the Bettis, triggered by the Bettis complaint, and I'm not, but if I am, the insurers now make a second move, and they say, wait a minute, if there's a prior wrongful act by any insured, there's no coverage in this complaint for all insureds. Right? So they want to expand this to say, at the end of the prior acts exclusion, they want to say, arising from or consequence of any wrongful act committed, et cetera, by any insured. But the words any insured don't appear there. They want to say any means all, any wrongful act means any wrongful act by any insured, there's no coverage for anybody. We put into our brief some discussion of the Ryan rule in Tennessee on the innocent co-insured issue. It was a case called, I'm sure you're familiar with the Ryan line of decisions, 1980 Tennessee Supreme Court, but it's followed throughout. And the Ryan case, and then there's a case called Finch that follows from Ryan, both say, put on the glasses, it says if the company wanted to assure its position, i.e. that the misconduct of any insured would bar recovery by any other insured, it might have made it clear and unambiguous in the policy, and it might have informed prospective applicants for insurance of this position from the start. It did not do so. Finch says the same thing. You can do this, you can do what they want to do, provided the specific language of the insurance contract does not expressly exclude such coverage so that the reasonable person purchasing insurance would expect to be covered in the event of a property loss caused intentionally by a co-insured. Tennessee law is very clear. If you want to expand an exclusion to apply to everybody, all insureds, you have to say so, and you have to say so clearly and explicitly. The insurers cite two cases. They cite the Jordan case and the Tutorea case, both Court of Appeals decisions. Both of those cases have very explicit language that say that the insured, wrongful act by one insured bars coverage for all insureds. Very, very specific language, which I'm happy to quote for you, but I don't want to take the time if I can move on. But here, the prior acts exclusion does not say a wrongful act by any insured bars coverage for all insureds. Just doesn't say it. That's what the insurers wanted to say. And in fact, they have a heading in their brief where they say, let me just quote it to you. They say, any pre-merger wrongful act triggers the prior acts exclusion for all insureds. That's a heading in their brief, in their reply brief. Right? Any pre-merger wrongful act triggers the prior acts exclusion for all insureds. That language isn't in there. It doesn't say that anywhere.
It says an insured.
Huh?
It says an insured.
An insured,
as
right.
opposed to the insured, I guess.
Yes, and so they talk about the word the versus and. If you go to the insuring agreements in the insurance policy, because the question is whether an insured is singular or multiple, right? Here's what the insuring agreements say, and they're promised to provide coverage to these directors and officers. I take this very seriously because I personally serve on a number of boards, and my concern would be that if the conduct of a co-board member could eviscerate my coverage, why would I sit on a board? Why would they sell? Who would buy that insurance? What corporate officer, risk manager would buy insurance for their board if the wrongful act of one insured can eviscerate coverage for all insureds? It can't possibly be a saleable policy or a marketable policy for these folks. The insuring agreement, in fact, says the company, which is the insurer, shall pay on behalf of each insured person loss for which the insured person is not indemnified by the organization, in which the insured person becomes legally obligated to pay on account of any claim first made against the insured person for a wrongful act committed by such insured person. That's insuring agreement 1. Insuring agreement 2 does the same thing. But there, insuring agreement 2 is the organization's indemnity obligation. Same thing. The company shall pay on behalf of the organization loss for which the organization grants indemnification to an insured person, in which the insured person becomes legally obligated to pay for a wrongful act by such person. All singular, right? This is a policy that provides coverage for individual directors and officers, and they're trying to say, one officer did something wrong, none of you have insurance. They do that by saying, by the way, that the Bettis complaint is one claim. You heard Ms. Ahari say exactly that. Remember that the Bettis complaint is a consolidated complaint. There were I think 6 lawsuits filed originally. They got consolidated into the one lawsuit. That's 8 counts, one count of which is a 10b-5 insider trading count. How can that possibly be related to these other cases? The Bettis complaint cannot be one complaint. And in fact, the case law supports just the opposite. I know there's no real Tennessee case law on this issue, but Tennessee courts, as Chancellor Martin noted, look to Delaware on lots of corporate law issues. This is clearly a corporate law issue. It's the protection for officers and directors of a corporation. The AT&T case from Delaware tells us, look at each count of the complaint and understand what wrongful acts are leading to that count. And then you can determine whether those counts are related and whether there's one claim or multiple claims. They take here many years, a number of years of alleged conduct, and they say, oh, it's all this same issue. It's all this out-of-network billing. That's not what the complaint says. All you have to do is go look at the headings of the Bettis complaint, and you'll see they're alleging all sorts of other things. I'm not admitting any of those things are true, but those are the allegations. They say that they misrepresented their quality of care, they misrepresented hospital contracts, all sorts of allegations in this comprehensive, almost 300-page complaint. And the insurers want to say, oh, that's one claim, and therefore, if the wrongful act bars coverage for one insured, it applies to all insureds, and if it applies to all insureds, it applies to all insureds for the only claim there is, which is the Bettis complaint. Can't be the law, can't be correct. In fact, if you look, the Bettis complaint in paragraph 21 says, the claims are asserted here arise under 10B, 14A, 20A, and 20 capital A of the Securities Exchange Act of 34, 15 U.S.C. 78JB, 78NA, 78TA, on and on and on. I mean, this complaint is wide-ranging, alleging all sorts of different conduct. So if you look at what they're saying, and let me just give you an example. There's a second amended Bettis complaint, which is not in the record because it came in after we had the record set in the trial court. But let me just, if you indulge me, we talk about it in footnote 5 of our brief. In that new amended complaint, there are 4 new post-merger wrongful acts alleged. One of which is a wrongful act alleged against a guy named Bob Neely, who's the vice president of Investor Relations. So he's alleged to have made a statement on March 21, 2017, post-merger statement by Bob Neely. Proving my point, if Bob Neely is alleged to have committed a wrongful act after March 1st, 2017, the insurers would say, he's not covered. It's a post-merger wrongful act, so it's in this policy. They would say he is not covered because somebody else made a statement sometime before that, and it's barred because of this wrongful acts exclusion, prior acts exclusion. If you don't have any more questions, I'll sit down. Thank you.
Thank you, Mr. Ginsburg. Ms. Ahari?
So several points. Number one, Bob Neely is not a defendant in the case. It's irrelevant. The additional misstatements added by the amended complaint all are of the same ilk of the earlier alleged misstatements that are in the joint proxy registration statement. So for that reason, we still have a claim, whether the claim is the 2 counts for which Envision seeks coverage, or if it's the entire lawsuit. It doesn't matter. Both counts 1 and 2 are based upon and arise from pre-merger wrongful acts, the joint proxy registration statement. And, in particular, this happened in the Chancery Court and repeated again here by Envision. Envision is conflating the meaning of claim and wrongful act. Each statement is not a separate claim. That was the decision in the AT&T case that Mr. Ginsburg relies on. It said that the counts were the claim. And in the First Solar case, which was a 2022 decision by the Delaware Supreme Court, the Delaware Supreme Court agreed that that the wrongful act is different from a claim. They are not the same thing. So it's important to keep that in mind. And then to Judge Davis's question as to, so where's the coverage for the post-merger conduct? In this case, the coverage for the post-merger statements by the Envision officers who were former directors of AmSurge are in the AmSurge policy. When Mr. Holden and Ms. Goulmy made the statements in the joint proxy registration statement, New Amethyst was at that time a subsidiary of AmSurge. So they are covered under that policy. There is no person or entity who is uninsured in this case, including Bob Neely, because he's not a defendant. So, and then the other thing I'll say is, I mentioned that I would.
We've been waiting on that.
So this is the definition of wrongful act. And what it really should have here is some ellipsis.
It should have what at the end?
The ellipsis.
Oh.
Less. So, and this was a mistake that the Chancery Court made as well. In quoting the definition of wrongful act, it includes an act or omission by an insured person in an insured capacity, or for the purposes of So wrongful act by the organization triggers the prior acts exclusion as to everybody. And we responded to Mr. Ginsburg's argument about severability at length in our reply brief. And what he doesn't address is that there's a specific provision in the policy concerning severability of exclusions. And that provision says severability applies to the exclusions in Section 7. The prior acts exclusion was added to the policy by endorsement. It is not in Section 7. And what is in Section 7 is the conduct exclusion. So if one insured person commits fraud, that doesn't get imputed to the other insured persons. But that's not what we're talking about here with respect to the prior acts exclusion. It's triggered by conduct by either the insured persons under this coverage section is the D&O coverage section, and it includes all 3 insuring agreements, insuring agreement 1 and 2, which apply to coverage for the insured persons, and insuring clause 3, which applies to coverage for the organization. So for that reason, the severability argument is clearly wrong, and and Judge Davis mentioned, there is a distinction between the insured and an insured. And the post-Ryan cases make that distinction crystal clear, and we address that in some detail in our reply brief. I am out of time, but happy to take any additional questions.
Hearing none, thank you.
Thank you very much.
Thank you both for your very interesting arguments, and we'll take this matter under advisement.